Picture a quiet neighborhood and a single home. Inside that home is a man who may be in distress. Perhaps he has said something alarming to a friend. Perhaps someone reported that he might be contemplating suicide. Outside the house, police officers are trying to decide what to do. They don't know exactly what's happening inside. They don't know the private thoughts of the person who lives there. They only have fragments of information, a report, a possibility, a concern that someone might be about to harm themselves. Acting on that information, the officers make a decision. They break down the door. What follows is tense, chaotic, and tragically ironic. In the confrontation that unfolds, the officers shoot the man they had entered the house to protect. And in a twist that sounds almost like dark satire, the state later charges him with a crime stemming from that encounter. This sequence of events eventually produced the United States Supreme Court decision, Case v. Montana. At first glance, the story has the shape of absurdity. A man survives being shot by police who were trying to prevent him from harming himself, and then finds himself prosecuted in court. But the irony could have even been darker. Imagine the alternative. If the officers had killed him during the entry, the state would have technically succeeded in preventing the suicide. After all, once someone's dead, they can no longer take their own life. The intervention would have achieved its immediate goal in the most disturbing way possible. In that scenario, there would have been no defendant, no trial, no appeals, and no Supreme Court case named Case. Instead, the man survived. And because he survived, the legal questions surrounding the incident continued moving through the courts until they reached the highest court in the country. Yet the Supreme Court didn't take up the case to decide whether suicide is rational. It didn't attempt to define the moral boundaries of despair or autonomy. And it did not declare that the police may freely enter homes whenever they suspect someone might own a firearm, regardless of what you've heard on other YouTube channels who are misinformed. In fact, the Supreme Court had already rejected that kind of broad authority only a few years earlier in Cornelia v. Strom. All these cases are linked in the description. You can read them for yourselves, and I encourage you to. They're easy reading. In that case, officers had entered the home without a warrant after concerns about the homeowner's mental health and removed his firearms. The court unanimously rejected the argument that the police possess a broad community caretaking power to enter homes whenever they believe it might be helpful or prudent. Justices warned explicitly against creating what they described as an open-ended license for law enforcement to enter private homes. The home, the court emphasized, remains the place where the Fourth Amendment protections are strongest. This case didn't change that. That earlier decision matters, because the Supreme Court in Case v. Montana actually cited Cornelia while explaining what the new case did not authorize. The court was careful to say that it was not granting police a free-ranging authority to enter homes in search of firearms or to conduct generalized welfare checks. Instead, the police addressed a narrower question. When officers have an objectively reasonable belief that someone inside a home is facing an immediate medical emergency, may they enter without a warrant in order to provide aid? That is a technical question about the Fourth Amendment. It concerns the limits of emergency intervention and the boundaries of police authority during a potential life-threatening crisis. But even as the court framed the issue in narrow legal terms, the facts behind the case point to something much larger. Because once the government claims the authority to break down a door in order to preserve a life, an uncomfortable question inevitably follows. If the state can intervene to prevent you from dying, what responsibility does it assume for the life it insists you must continue living? That question sits quietly beneath the case. And once you begin to examine it closely, it leads directly to one of the deepest contradictions in modern public policy. When the Supreme Court released its decision in Case v. Montana, The legal community began analyzing it almost immediately. That's normal for any Supreme Court case. What was less normal was how quickly the decision became the subject of viral commentary online. Within days, and in some places within hours, claims began circulating that the court had just authorized police to enter the homes of gun owners without a warrant in order to confiscate firearms. The narrative spread quickly across social media platforms, discussion forums, and political commentary channels. Headlines and posts began to frame the case as a dramatic new expansion of police power. The message was simple and alarming. The government can now enter your home without a warrant if they think you might have guns and might harm yourself. That interpretation was compelling in a way many viral interpretations are compelling. It fit neatly into existing fears about government overreach. It connected to ongoing political debates about gun rights and mental health interventions. And it reduced a complicated constitutional question into a simple and emotionally powerful claim. There was just one problem. It was wrong. Not slightly wrong. Not technically misleading. Fundamentally wrong. To understand why, we need to step back and look at the legal framework the court was actually working within. The case was not about creating a new police power. It was about clarifying how an already existing constitutional doctrine should be applied. At the center of the decision is the Fourth Amendment to the United States Constitution. The Fourth Amendment protects people from unreasonable searches and seizures by the government. One of its most famous and enduring principles is that police generally must obtain a warrant from a judge before searching a private home. This rule reflects a deep historical tradition that predates the United States itself. The idea that the home is a protected space, one that the government cannot simply enter at will, was a central grievance of the American colonists under British rule. Colonial authorities had used sweeping search powers and general warrants to enter homes and search for contraband without specific judicial authorization. The backlash against those practices became one of the foundations of American constitutional law. Over time, the Supreme Court has repeatedly emphasized that the home occupies a unique place in Fourth Amendment doctrine. It is a place where constitutional protections are strongest. The phrase, "a man's home is his castle," captures this intuition. The home is meant to be a sanctuary from arbitrary government intrusion. But constitutional protections are rarely absolute. From the earliest days of Fourth Amendment jurisprudence, courts have recognized that there are situations where requiring a warrant before entering a home would be impractical or even dangerous. These situations are sometimes referred to collectively as exigent circumstances, emergencies in which waiting for a warrant could lead to serious harm. If the police are chasing a fleeing suspect who runs into a house, they may follow, without stopping to obtain judicial approval. If officers hear screams from inside a home, suggesting someone is being assaulted, they may enter immediately. If they believe someone inside is gravely injured and in need of immediate medical assistance, they do not have to stand outside while paperwork is prepared. One of the most important branches of this broader emergency doctrine is known as the emergency aid exception. Under the emergency aid doctrine, police may enter a home without a warrant when they have a reasonable basis to believe someone inside is seriously injured or facing an imminent threat of injury. The purpose of the entry is not to investigate a crime or search for evidence. It is to render aid, to prevent death or serious harm. This doctrine did not originate in Case v. Montana. It had already been recognized by the Supreme Court in earlier decisions, including Brigham City v. Stewart and Michigan v. Fisher. In Brigham City, the officers responded to a loud party where a fight had broken out. Looking through a window, they saw a juvenile punch an adult in the face, causing the adult to spit blood. Officers entered the home without a warrant to stop the violence. The Supreme Court unanimously held that the entry was lawful because officers had an objectively reasonable basis to believe someone inside was being seriously injured. In Michigan versus Fisher, officers responded to a disturbance and found a chaotic scene: broken windows, blood on a vehicle, and a man inside the house behaving erratically. The court again held that officers could enter without a warrant because the circumstances suggest someone might be injured or in need of assistance. These cases established an important principle. When officers reasonably believe someone inside a home is facing immediate harm, the Constitution allows them to act quickly, rather than wait for judicial authorization. By the time Case v. Montana reached the Supreme Court, no one seriously disputed the existence of this doctrine. Both sides in the case acknowledged that the emergency aid exception exists. The real dispute concerned the legal standard that should apply. Some courts had suggested that officers must have probable cause, the same standard typically required to obtain a warrant before entering a home under the emergency aid exception. Probable cause is a relatively demanding threshold. It requires a substantial factual basis to believe that a particular condition exists. Other courts have applied a somewhat less demanding standard, asking whether officers had an objectively reasonable belief that an emergency existed. The difference may sound subtle, but in practice, it can matter a great deal. Emergencies are often chaotic and ambiguous. Information arrives in fragments. Officers must make decisions quickly, sometimes with incomplete or conflicting reports. The Supreme Court in Case v. Montana resolved this disagreement. The justices unanimously held that officers do not need probable cause to enter a home in order to render emergency aid. Instead, the relevant question is whether the officers had an objectively reasonable belief that someone inside needed immediate assistance. In practical terms, this means the court should evaluate the situation from the perspective of a reasonable officer, assuming that exists, confronting the circumstances at the time. The question is not whether the emergency later turns out to have been real. The question is whether the officers reasonably believed it might be. Importantly, the court did not treat this doctrine as an open invitation for police to enter homes whenever they believed it might be helpful. In fact, the justices were careful to emphasize the limits of the rule. The court specifically referenced Cornelia v. Strom, a recent case, 2021, in which the court unanimously rejected the idea that police have broad community caretaking power to enter homes for general welfare purposes. In Cornelia, officers entered a home and removed firearms after concerns about the homeowner's mental health. The court rejected the argument that police possess a sweeping authority to enter homes simply because they believe it might promote safety. The justices warned against creating what they describe as an open-ended license for law enforcement officers to enter private homes. That language appears again in Case, where the court made clear that the emergency aid doctrine is not a general permission slip for government intrusion. It is a narrow exception tied specifically to immediate threats to life or safety. In other words, the court did not say that the police may enter homes to search for firearms. It did not say that gun ownership creates a special category of suspicion. And it did not grant officers a broad authority to conduct warrantless welfare checks inside private residences. What the court did say was far more limited. When officers have an objectively reasonable basis to believe that someone inside a home is seriously injured or facing imminent harm, they may enter without first obtaining a warrant in order to provide aid. That is the rule. It's not new, it's not radical, and it is far narrower than many early interpretations suggest. Legally speaking, the court resolved a technical disagreement about how an existing doctrine should be applied. The decision clarified the standard courts use when evaluating emergency entries into homes. But the facts that brought this case to the court the attempted suicide, the forced entry, the shooting, and the prosecution that followed raise questions that extend far beyond technical constitutional doctrine. Because once we accept that government may break down a door in order to save a life, a deeper question inevitably emerges. What does society owe the life it insists on preserving? The officers in this case forced entry into the home because they believed the resident might be attempting suicide. From the perspective of the legal system, that belief transformed the situation into an emergency. Police were not entering to investigate a crime, and they were not executing a warrant. They were acting under the assumption that someone inside the house might be about to die by his own hand. Within the framework of modern law, that possibility triggers intervention. Police respond. Medical professionals may become involved. In many states, a person suspected of attempting suicide can be detained for a psychiatric evaluation against their will. The justification is straightforward. The state has an interest in preventing irreversible harm, particularly when the individual involved may not be thinking clearly in the moment. But as soon as we step back and examine the legal logic more closely, we encounter a remarkable contradiction. In many other contexts, the law explicitly recognizes a right of individuals to make decisions that will lead directly and predictably to their own death. This principle was acknowledged by the Supreme Court in Cruzan versus Director of Missouri Department of Health. The case involved a young woman named Nancy Cruzan, who had been left in a persistent vegetative state after a car accident. Her family wished to remove the feeding tube that was keeping her alive, believing that she would not have wanted to continue living under those circumstances. The legal question was whether the Constitution protects an individual's right to refuse medical treatment, even if refusing that treatment results in death. The court ultimately concluded that competent adults possess a constitutionally protected liberty interest in refusing unwanted medical care. In other words, the government cannot force medical treatment on a competent person simply because the treatment might save their life. The implications of that principle are profound. A person diagnosed with cancer may decline chemotherapy, even when doctors believe the treatment could prolong their life. A person suffering from a heart condition may refuse surgery that would likely save them. Someone dependent on a ventilator may choose to have that ventilator removed. In each of these cases, the outcome may be death. Sometimes the outcome is almost certain. Yet, the law treats these decisions as legitimate expressions of personal autonomy. The reasoning is grounded in the idea that individuals possess sovereignty over their own bodies. Medical treatment, even life-saving treatment, requires consent. Without consent, it becomes a form of coercion and assault. In this context, choosing a course of action that leads to death is not treated as evidence of irrationality. Instead, it is understood as an exercise of self-determination. A patient may weigh the burdens of treatment, the quality of life they expect to experience, and their own personal values. After considering those factors, they may conclude that continuing treatment is not the path they wish to take. The law does not insist that they must continue living at all costs. But now, consider what happens when a person attempts suicide. In that context, the legal system typically adopts the opposite assumption. The individual's decision is not treated as a legitimate exercise of autonomy. Instead, it is presumed to be the product of impaired judgment. Police intervene. Emergency medical personnel intervene. Courts may authorize involuntary psychiatric detention. Medical professionals may treat the individual against their will, at least temporarily, until they are deemed no longer to be a danger to themselves. The underlying assumption is that suicidal intent reflects a temporary failure in rational decision-making. Depression, acute distress, intoxication, and other forms of psychological crisis are believed to compromise the individual's ability to make fully autonomous choices, because the consequences of suicide are permanent and irreversible. The state asserts a duty to intervene during the moment of crisis. The contrast between these two legal frameworks is striking. In one situation, choosing a course of action that leads to death is considered a rational exercise of autonomy. In another situation, choosing death is treated as evidence that autonomy itself has broken down. In one context, the law respects the decision. In another, it overrides it. The outcome, death, is the same in both cases. What differs is the surrounding narrative about the person making the decision. When a patient refuses medical treatment, the decision is framed as deliberate and thoughtful. When a person attempts suicide, the decision is framed as desperate and irrational. Of course, there are understandable reasons for this distinction. Suicide attempts are often associated with mental health crises. Many people who survive suicide attempts later report that they are grateful the attempt did not succeed. The law reflects a belief that moments of suicidal despair are often temporary, and that intervention can preserve a life that may later regain meaning and stability. But even acknowledging these realities does not entirely resolve the paradox, because the law ultimately rests on the assumption about the internal state of the person involved, an assumption that may not always be correct. No external observer can fully know the internal landscape of another person's experience. The suffering that leads someone to contemplate suicide is often invisible, deeply personal, and difficult to measure. For some individuals, the decision may indeed arise from a temporary crisis that will eventually pass. For others, it may emerge from years of unrelenting pain, illness, trauma, or despair. The legal system cannot easily distinguish between these possibilities, yet it must act as though it can. This uncertainty raises an uncomfortable philosophical question. Is the decision to end one's life inherently irrational? Or could it sometimes be the most rational choice available to a person whose suffering cannot be fully understood from the outside? Different cultures and different philosophical traditions have answered that question in different ways. Some traditions condemn suicide as morally unacceptable under any circumstances. Others recognize situations where ending one's life may be viewed as an expression of dignity or agency. Modern law tends to avoid confronting this question directly. Instead of making a sweeping statement about the rationality or morality of suicide, the legal system reframes the issue in institutional terms. Rather than asking whether suicide is rational, courts ask whether the state has a legitimate interest in preventing it. This shift in perspective moves the conversation away from an individual's internal reasoning and toward the broader responsibilities of society. The question becomes less about the psychology of the person contemplating suicide and more about the role of the state in preserving human life. And that brings us to the next step in the argument. If the state can claim an interest in preserving life, even against the wishes of the person living that life, what responsibilities follow from that claim? The Supreme Court confronted the question of suicide and the role of the state most directly in Washington versus Glucksberg. That case arose from a challenge to a Washington state law that prohibited physician-assisted suicide. Several physicians and terminally ill patients argued that the Constitution should protect the right of a competent adult to seek medical assistance in ending their life when suffering from incurable and debilitating conditions. The argument rested on the broad concept of personal liberty embedded in the Due Process Clause of the 14th Amendment. Over the years, the Supreme Court has interpreted that clause to protect certain deeply personal decisions from government interference, decisions about marriage, family life, and bodily autonomy. The plaintiffs in Glucksberg argued that the decision about whether and when to end one's life should fall within the same sphere of protected liberty. The court disagreed. In a unanimous decision, the courts concluded that the Constitution does not recognize a fundamental right to assisted suicide. They emphasized the long historical tradition of laws prohibiting suicide and assisting suicide. The court also pointed to the practical concerns that arise when the medical profession becomes involved in deliberately ending life. But the reasoning did not stop there. Throughout the decision, the court repeatedly invoked a broader justification. The state has a legitimate interest in preserving human life. The phrase appears in different forms throughout the opinion, but the underlying idea remains constant. Governments have long claimed a responsibility to protect life, not only from violence inflicted by others, but also, in certain circumstances, from self-inflicted harm. In the court's view, allowing assisted suicide could undermine several important societal interests. One of those interests is the protection of vulnerable individuals who might feel pressure, whether explicit or subtle, to end their life, because they perceive themselves as burdens on their family or on society. Another concern involves the integrity of the medical profession. Physicians are traditionally understood as healers. The court expressed concern that transforming doctors into agents of death could blur ethical boundaries and erode trust in the medical system. These are serious considerations, and the court treated them as such. But the most fundamental principle underlying the decision remains the simplest one. The state has an interest in preserving life. At first glance, that statement almost seems self-evident. Life is a foundation upon which all other human experiences are built. Without life, there can be no freedom, no dignity, no relationships, no aspirations. It is therefore unsurprising that most societies treat the protection of life as one of the core responsibilities of government. Laws against murder and assault exist to safeguard life from the harm inflicted by others. Emergency services exist to rescue people from accidents and disasters. Public health systems attempt to prevent disease and extend human longevity. In countless ways, modern society organizes themselves around the idea that life should be protected and preserved. But once we pause and examine the phrase more closely, a deeper question begins to emerge. What does it actually mean for a state to have an interest in preserving life? Is that interest purely biological, focused on ensuring that life continues in the most basic sense? Or does it carry a broader moral implication? When the government intervenes to prevent a person from dying, it is exercising power over the most fundamental aspect of human existence. It is effectively declaring that the continuation of that life is a matter of public concern, not merely a private choice. If the state asserts that authority, we might reasonably ask whether the responsibility ends the moment the immediate crisis passes. Imagine a person standing on the edge of a bridge, contemplating suicide. Officers arrive and pull the person back to safety. In that moment, the state's interest in preserving life is fulfilled. The person does not die. The immediate danger has been averted. But what happens next? Does the state's responsibility end at that moment? Once the person has been pulled back from the edge, does society simply step aside and leave them to face the same conditions that led them there in the first place? Or does the act of intervention carry a deeper implication that preserving life also entails some responsibility for the circumstances under which that life continues? This is where the legal principle begins to intersect with moral philosophy. The idea that the state has an interest in preserving life does not exist in isolation. It sits within a broader framework of political thought that attempts to explain why governments exist and what obligations they owe to the people who live under their authority. Political philosophers have wrestled with these questions for centuries. Some have argued that the primary function of government is simply to maintain order and protect individuals from violence. Others have argued that the legitimacy of government depends on its ability to promote human flourishing, to create the conditions under which people can live stable, meaningful lives. When the state intervenes to prevent someone from dying, it is implicitly taking a position within this philosophical debate. It is asserting that life itself is valuable enough to justify overriding individual autonomy in moments of crisis. That assertion carries moral weight. If life is valuable enough to preserve against someone's immediate wishes, then it becomes difficult to argue that the quality and sustainability of that life are irrelevant. In other words, once a state claims an interest in preserving life, the new question inevitably follows. What obligations accompany that interest? Does society merely ensure that people remain alive in a narrow biological sense, regardless of the conditions they face? Or does the commitment to preserving life imply a responsibility to create the basic conditions that allow life to be lived with dignity? These questions push us beyond the boundaries of constitutional doctrine and into the deeper territory of political philosophy. They force us to ask not only what the law permits, but what justice requires. And once we begin to explore those questions, we find ourselves confronting a broader tension in modern society: the gap between the power to preserve life and the willingness to support the lives that are preserved. To understand why the state claims authority over matters as intimate as life and death, we need to step outside the courtroom for a minute and step into the long conversation of political philosophy. For centuries, thinkers have struggled with a deceptively simple question: why do governments have authority over individuals at all? Human beings are born free in a very literal sense. No government exists in nature. No state appears spontaneously in the wilderness. Authority is something societies construct. Laws exist because people collectively decide that they should exist. Governments wield power because individuals, in one way or another, accept that power as legitimate. But how does that legitimacy arise? One of the most influential answers to this question is a theory known as the social contract. According to this idea, political authority emerges from an implicit agreement among individuals. In order to escape chaos and insecurity, people consent, either explicitly or implicitly, to surrender some of their natural freedom in exchange for the protections offered by an organized society. The details of this contract differ depending on the philosopher explaining it, but the underlying structure remains consistent. Individuals give up certain liberties so that they can live under a system that provides safety, order, and stability. And if you're considering the Franklin quote, watch this video to understand it. One of the earliest and most dramatic versions of this theory was developed by Thomas Hobbes in the 17th century. Hobbes imagined what life would be like without any form of government, a condition he famously described as the state of nature. In this hypothetical world, every person would be responsible for protecting themselves from everyone else. There would be no laws, no courts, no institutions capable of resolving disputes. In Hobbes' bleak description, life in such a world would be solitary, poor, nasty, brutish, and short. Violence and insecurity would dominate everyday existence because no authority would exist to enforce the rules or protect individuals from harm. To escape that chaos, Hobbes argued people would rationally agree to surrender some of their freedom to a central authority capable of maintaining order. The state, in this view, exists primarily to prevent the violence and instability that would otherwise define human life. A generation later, John Locke developed a somewhat different version of the social contract. Locke also imagined a state of nature, but his version was less bleak than Hobbes'. In Locke's view, individuals possess natural rights, even before government exists, rights to life, liberty, and property. The problem, Locke argued, is that without an organized system of laws and courts, those rights are difficult to enforce. Individuals may disagree about what justice requires, and disputes can quickly escalate into conflict. The solution is to create a government whose primary role is to protect those natural rights. In Locke's formulation, the legitimacy of government depends on its ability to safeguard the rights of the people. If a government fails in that task, citizens retain the right to challenge or even replace it. Later still, Jean-Jacques Rousseau offered another interpretation of the social contract. Rousseau focused less on protection and more on the idea of collective self-governance. For him, the social contract was not merely an exchange of freedom for security, but a process through which individuals collectively shaped the rules that govern their society. Despite their differences, these thinkers share a common insight. The authority of government does not exist in isolation. It arises from a relationship between the state and the individuals who live under its power. The state gains authority. Citizens gain security. The arrangement is meant to benefit both sides. In theory, this relationship is balanced. Individuals give up certain freedoms, such as the freedom to resolve disputes through violence, in exchange for protections provided by law, order, and social stability. But the balance becomes even more complicated when the state claims authority over something as fundamental as the continuation of life itself. When the government intervenes to prevent someone from dying, it is not merely enforcing a traffic law or collecting taxes. It is exercising power over the most basic aspect of human existence, whether a life continues or ends. In that moment, the state is asserting that the preservation of that life is not solely a private matter. It is a matter of public concern. That assertion carries profound implications. If the state has the authority to override the individual's decision to die, if it can break down the door, intervene in a crisis, or impose medical treatment in order to preserve life, then the relationship between the individual and the state becomes deeper and more complicated than the simple exchange described in traditional social contract theory. Because once the state claims authority over life itself, a moral question inevitably arises. What obligations accompany that authority? If a society insists that a life must continue, even when the individual might prefer otherwise, the society also bears responsibility for the conditions under which that life continues. Does the social contract imply merely that individuals must remain alive? Or does it imply that society should ensure the basic conditions necessary for a life that can be lived with dignity? These questions move us beyond the narrow legal reasoning of court cases and into the broader ethical structure of political life. If the purpose of government is merely to prevent chaos, perhaps the obligation ends once biological survival is secured. The state intervenes, preserves life, and then steps back. But if the purpose of government includes protecting human rights and promoting human flourishing, the answer may be different. In that framework, preserving life cannot be separated from the conditions that make that life livable: food, shelter, healthcare, basic security. These are not luxuries in such a framework. They are the foundations that allow individuals to exercise the freedoms the social contract was meant to protect. This tension between the preservation of life and the quality of the life preserved becomes even more striking when we examine how the same logic appears in another area of modern public policy. Because the question of whether the state has the authority over life does not only arise at the end of life, it also arises at the very beginning. Debates about suicide, autonomy, and state intervention often focus on the end of life. But they are only one side of a broader question. When, if ever, should the government assert authority over the most fundamental dimensions of human existence? A striking parallel exists in the debate over abortion. While suicide policy concerns the prevention of death, abortion policy concerns the protection of potential life. In 2022, the Supreme Court's decision in Dobbs versus Jackson Women's Health Organization dramatically shifted the legal landscape in the United States. By overturning federal constitutional protections for abortion rights, Dobbs returned the power to regulate abortion to individual states. The rationale offered by supporters of abortion restrictions centers on the protection of unborn life. Really, the primacy of unborn life. The government, in these cases, asserts a direct interest in ensuring that potential life becomes actual life. It claims authority over one of the earliest possible points of existence, the very moment when a new human life begins. In effect, the state is asserting that it has a moral and legal stake in whether a person enters the world at all. When we juxtapose this with policies surrounding suicide, the similarity is striking. Suicide prevention laws operate at the opposite end of the spectrum. They allow the state to assert authority over whether a life ends. Police officers, emergency services, and medical personnel may intervene to prevent a person from taking their own life, overriding autonomy in the name of preserving existence. In both domains, abortion and suicide prevention, the state is claiming a moral and practical authority over the continuity of human life. The underlying principle is the same. Life must continue. In one case, it must be born, and in the other, it must not end. But this principle exposes a moral asymmetry in how policy is constructed and implemented. The focus of public attention, resources, and legal enforcement often remains on the mere fact of existence, rather than the quality or conditions of that life. In the case of birth, significant legal and political energy is expended to ensure that a child is born, even in circumstances where the child may face deep social, economic, or medical disadvantage. Policies that prevent abortion are celebrated as protecting life, yet there is often minimal corresponding investment in ensuring that the life protected can be lived with dignity and security. Similarly, in the case of suicide prevention, society may intervene to preserve life at the moment of crisis, breaking down doors, imposing emergency medical care, and enforcing psychiatric holds. But there's often little attention paid to the ongoing circumstances that led the individual to despair. Poverty, chronic illness, mental health conditions, social isolation, and economic insecurity are frequently left unaddressed. The asymmetry is difficult to ignore. Life is preserved at its beginning. Life is rescued at moments of imminent threat. Yet the ongoing quality, stability, and dignity of that life are often treated as secondary concerns, or as issues outside the moral and legal responsibility of the state. If the government claims the authority to assert that life must begin, and also claims the authority to assert that life must continue, then it is difficult to argue convincingly that its moral obligation ends with biological survival. Insisting on existence, without also creating conditions for livable, meaningful, and supported lives, leaves a glaring ethical gap. This tension raises a central question. If life must begin and life must continue, does society not also have some responsibility for the circumstances under which that life unfolds? If existence is treated as valuable, can the value be meaningfully claimed while ignoring the foundational social, economic, and health conditions that sustain it? Ultimately, when we examine abortion restrictions and suicide prevention side by side, the symmetry becomes clear. Both are about the state asserting authority over life itself. Both invoke moral and legal claims about the value of life. But in both cases, asserting authority without accompanying responsibility risks transforming moral claims into hollow commands. Life must continue, but under conditions largely determined by chance, inequality, or societal neglect. This observation sets the stage for a broader discussion about what it truly means to value human life and what society must do if it claims that such life is worth preserving. At this point in the discussion, the legal questions that began with Case versus Montana have opened into something much larger. What started as a technical dispute about warrantless entry and the emergency aid doctrine now touches on one of the deepest questions a society can face. What do we owe one another simply by virtue of being alive together? When we follow the logic of the previous sections to its conclusion, we arrive at a kind of ethical crossroads. Not a partisan one, not a narrow policy disagreement. A structural moral choice about how society understands life, autonomy, and responsibility. Broadly speaking, there are two coherent philosophical directions society could choose. Both have internal logic. Both can be defended. But they lead to very different kinds of social systems. The first path is radical autonomy. The first path places individual autonomy at the center of moral and political life. Under this philosophy, individuals are understood to possess ultimate authority over their own bodies and their own existence. Life belongs to the person living it. The state may provide guidance, support, or resources, but it does not claim ownership over the fundamental decisions that shape a life. Within such a framework, reproductive decisions belong to the individual. A person may decide to continue a pregnancy. A person may decide whether to terminate one. Similarly, the decisions about whether one's own life should continue ultimately belong to the individual experiencing that life. Under a fully autonomy-centered model, a person could decide that their suffering has become intolerable and that their life circumstances have become unbearable, or simply that they no longer wish to continue living. Society may try to help. Friends, family, counselors, and medical professionals may intervene with compassion and support. But the final decision would remain with the individual. This philosophical perspective places enormous weight on personal liberty. It reflects a deep commitment to the idea that autonomy is the foundation of human dignity. A life that cannot be directed by the person living it risks becoming something closer to a biological process than a fully human existence. Under this view, forcing someone to continue living against their will could be seen as a violation of the same bodily autonomy principles that protect the right to refuse medical treatment or the right to make decisions about reproduction. But radical autonomy has implications beyond these deeply personal decisions. A society that emphasizes autonomy above all else might also adopt a more limited understanding of collective responsibility. If individuals are primarily responsible for directing their own lives, the role of society may be viewed as more constrained. The government protects rights, it enforces contracts, it maintains order. But it does not necessarily guarantee outcomes. Economic inequality, lack of health care, unstable housing, and other hardships may be seen as unfortunate realities rather than collective obligations. The system protects freedom of choice, but it does not necessarily ensure that every person has the resources needed to build a secure life. In such a system, autonomy is paramount, but the safety net may be thinner. The second path is collective responsibility. The second path begins with a different premise. Instead of placing autonomy above all else, it emphasizes interdependence of human life. Under this philosophy, individuals are understood not as isolated actors, but as members of a community whose lives are deeply intertwined. Within this framework, society may claim a legitimate interest in preserving life itself. Suicide may be discouraged or prohibited because the loss of a life affects not only the individual but the entire community. Similarly, restrictions on abortion may be justified by the belief that potential life deserves protection from the earliest stages of development. In this model, the state asserts authority over both the beginning and the end of human existence. But the authority carries moral consequences. If society insists that a life must continue, if it claims the right to prevent suicide and the authority to require birth, then it cannot easily avoid responsibility for the conditions under which those lives unfold. A society that claims this authority cannot plausibly say, "You must live, but how you live is entirely your problem," because the act of preserving life creates a relationship of obligation. If life must exist, then the conditions necessary for a decent life should exist as well. Food, shelter, healthcare, education, basic economic stability. These are not luxuries under this framework. They become the structural supports that make the preservation of life morally meaningful. Without them, the insistence that life must continue begins to sound less like a commitment to human dignity and more like a demand for endurance. Survival, in its most minimal sense, is not the same as flourishing. A society that merely keeps people alive while leaving them trapped in poverty, illness, or insecurity may technically preserve life, but it does little to honor the value it claims life possesses. In this framework, a strong social safety net is not simply a matter of compassion or charity. It becomes a logical consequence of the state's claim that life itself must be preserved. If the government asserts authority over whether life may end, it assumes at least some responsibility for whether that life can be lived with stability and dignity. But there's a contradiction in practice. The ethical tension emerges when a society attempts to claim the authority of the second model, while practicing the indifference of the first. This is the contradiction that appears repeatedly in modern political debates and is completely missing in religious discussions. A society may prohibit assisted suicide. It may intervene to stop someone from taking their life. It may restrict abortion in the name of protecting potential life. These actions assert a powerful moral claim that human life must be preserved. But if that same society simultaneously declines to ensure access to health care, housing, nutrition, or economic security, the logic begins to fracture because the message becomes inconsistent. Life must continue, but the conditions of that life are not society's concern. You must exist, but whether that existence is sustainable, dignified, or secure is largely your responsibility. At that point, the claim that society values life begins to ring hollow. Preserving life while ignoring the conditions that make life livable is a strange form of moral commitment. It resembles a system that demands endurance without offering support. And that contradiction brings us back to where this entire discussion began, with a police officer breaking down a door in order to prevent a man from dying. In that moment, the state asserted that his life mattered enough to intervene. A deeper question, the one that echoes far beyond the facts of that single case, is what that assertion truly means. Interestingly, the idea that preserving life carries an accompanying responsibility to sustain it is not unique to modern political philosophy. Versions of this principle appear across many of the world's major moral and religious traditions. In fact, long before economists debated welfare systems or political theorists discussed the structure of the social contract, religious traditions were already wrestling with a related question. What do human beings owe one another simply because they share a community? Across cultures and centuries, the answer often points to a similar direction. Preserving life is not merely about preventing death. It is about sustaining human dignity. Consider the teachings associated with Jesus Christ. Within the Christian tradition, moral duty is repeatedly framed in terms of care for the vulnerable. The hungry are to be fed, the poor are to be supported, the sick are to be cared for, the stranger is to be welcomed. Perhaps the clearest illustration appears in the parable often called the Good Samaritan. In that story, a traveler is beaten and left on the side of the road. Several passers-by see the injured man but continue walking. Only a Samaritan, someone belonging to a group viewed with suspicion by the original audience, stops to help. He tends to the wounded man's injuries. He transports him to shelter. He pays for his care. The moral lesson of the story is not merely that harming others is wrong. The deeper lesson is that seeing suffering and ignoring it is also a moral failure. Compassion is not optional. It is an obligation that arises when one human being encounters the vulnerability of another. This theme appears again in the famous passage describing the Last Judgment, when acts of compassion are treated as moral touchstones. Feeding the hungry, giving drink to the thirsty, clothing the naked, visiting the sick and imprisoned. These actions are presented not as acts of extraordinary charity, but as basic expressions of moral responsibility. Within this framework, the value of human life is inseparable from the obligation to care for the people living those lives. A similar principle appears in Jewish ethical thought. Jewish tradition contains a powerful concept known as pikuach nefesh, the obligation to preserve human life. Under this principle, nearly all religious commandments are to be set aside, if doing so is necessary to save a life. The preservation of life is considered so important that it overrides many other rules. But Jewish ethics does not stop with emergency intervention. The tradition also contains strong commitments to communal support for the poor and the vulnerable. Concepts such as tzedakah, often translated as charity but more accurately understood as justice, frame assistance to those in need not as voluntary generosity, but as a moral duty embedded within the community itself. Helping the poor is not simply a good idea, it is an act of justice that reflects shared responsibility of the community. Islamic teachings contain a closely related framework. Within Islamic ethics, charity and social responsibility are not peripheral virtues, but foundational pillars of faith. One of the 5 pillars of Islam is zakat, a structured system of giving designed to support the poor the indebted, and others facing hardship. Zakat is not optional philanthropy. It is a required redistribution of wealth, intended to ensure that the basic needs of members of the community are met. Beyond zakat, Islamic teaching repeatedly emphasizes compassion, mercy, and the responsibility to care for others who are vulnerable or struggling. Taken together, these traditions reveal a recurring pattern. Preserving life is not understood as a narrow biological goal. It is tied directly to the broader project of sustaining human dignity. A society that values life must also value the conditions that allow life to flourish: food, shelter, care for the sick, support for those who fall into hardship. These elements are not treated as secondary considerations, but as moral imperatives that flow naturally from the recognition that human life has intrinsic worth. Even traditions outside the Abrahamic religions often echo similar themes. Many philosophical systems emphasize compassion, mutual aid, and the interdependence of human beings. Whether framed as moral duty, spiritual practice, or civic virtue, the core insight remains strikingly consistent. Human beings are not meant to face the challenges of life entirely alone. Communities exist, in part, to ensure that the burdens of survival are not borne by individuals in isolation. This perspective casts the earlier discussion in a new light. When the state intervenes to prevent a person from dying, when it asserts that a life must be preserved, it is acting in a way that resonates with many long-standing moral traditions. The preservation of life is widely seen as good. But those same traditions rarely treat the preservation of life as a single isolated act. Saving a life is the beginning of a responsibility, not the end of it. The moral duty does not end at birth. It does not end once a suicide attempted has been interrupted. It does not end once a person has been pulled back from the edge of crisis. Instead, the responsibility continues throughout the life the society has chosen to protect. To preserve life while ignoring the conditions under which that life unfolds would appear, from the perspective of many moral traditions, incomplete at best, and hypocritical at worst. The commitment to life carries with it a commitment to the people living those lives. And that insight leads naturally to the final question of this entire discussion. If we claim that life must be preserved, what kind of society must we build to make that claim morally credible? After traveling through constitutional doctrine, political philosophy, and moral tradition, it is worth returning to where this entire discussion began. A single moment at a single home involving a single individual. The Supreme Court's case in Case versus Montana, and I haven't forgotten that's how this discussion started, did not attempt to resolve the sweeping ethical questions we've been exploring. The justices were not asked to determine whether suicide can ever be rational. They were not asked to decide whether the government has a moral obligation to guarantee housing, health care, or economic security. They were not even asked to weigh the philosophical meaning of autonomy. Instead, the court addressed a narrower constitutional issue: when police officers may enter a home without a warrant under the emergency aid doctrine. The Fourth Amendment has long treated the home as the most protected space in American law. The basic rule is clear: police generally cannot enter a home without a warrant issued by a judge. But there are exceptions, and one of those exceptions arises when officers reasonably believe that someone inside the home is in immediate danger and needs help. The court's decision in Case clarified the standard governing that situation. The justices held that officers may enter if they have an objectively reasonable belief that someone inside needs emergency assistance. That conclusion did not create a new doctrine. It did not authorize broad searches for weapons. In fact, the court explicitly rejected the idea that officers possess an open-ended license to enter homes simply to look for firearms, a principle the court had already emphasized in Cornelia v. Strom. Legally speaking, the decision resolved a technical disagreement among lower courts about the level of certainty required before officers can act in an emergency. From the perspective of constitutional doctrine, the ruling is relatively modest, but the human story behind the case remains anything but modest. Because behind the legal arguments and citations sits a moment of extraordinary tension. Police officers forced their way into a private home because they believed someone inside might attempt suicide. They did not arrive to investigate a crime. They arrived because they believed a life might end soon. In doing so, they acted on one of the most powerful claims a state can make, that preserving human life is a legitimate public interest. This idea appears repeatedly throughout American law. It appears in decisions like Washington versus Glucksberg, where the court emphasized the state's interest in preventing suicide. It appears in countless emergency interventions carried out by police, firefighters, and medical personnel every day. It appears whenever the government steps in to stop someone from dying. When that intervention occurs, the state is asserting something profound. It is saying that this life matters enough to justify overriding the ordinary boundaries of privacy, autonomy, and property. It is saying that even if the individual inside the home may wish to end their life, society claims an interest in preventing that outcome. In the case that produced Case versus Montana, the claim took the form of a forced entry into a private dwelling. The door was broken. The confrontation unfolded. A life was preserved, at least in the immediate sense. But that moment, the moment of intervention, raises a question that the legal system itself rarely addresses. What happens after the door has been broken? What happens after the immediate crisis has passed? When the state exercises its authority to preserve life, it does so in the name of a moral principle, that life has value and should be protected. But that act of preservation is only the beginning of the story. Once the crisis ends, the individual whose life was preserved still exists within the same social conditions that shaped their circumstances in the first place. The suffering that led to despair may still be present. The economic pressures may still exist. The health challenges, the isolation, the instability, whatever forces contributed to the moment of crisis, may remain largely unchanged. In other words, the act of preserving life does not automatically resolve the conditions that made the life feel unbearable. And this is where the deeper tensions become visible. Because when the state intervenes to prevent death, it is not acting as a neutral observer. It is exercising power. It's asserting that the continuation of this life is important enough to justify extraordinary action. The questions that naturally follow are whether the assertion carries continuing obligations. If the state can break down a door to stop someone from dying, what does it owe that person once the door has been broken and the life has been preserved? Does its responsibility end with the intervention itself? Or does the act of preservation create a deeper relationship between society and the individual whose life it has chosen to protect? The Supreme Court did not attempt to answer that question in Case versus Montana. But the case places a question squarely in front of us. Because once society claims the authority to preserve life, it must eventually confront the deeper question of what that commitment truly means. A society that declares human life to be valuable must eventually confront the implications of that belief. At first glance, the statement seems almost too obvious to question. Nearly every culture, legal system, and moral tradition affirms the value of human life in some form. Laws against murder exist in every functioning society. Emergency responders risk their own safety to rescue people in danger. Families, communities, and institutions routinely mobilize to protect individuals facing harm. But when we say that life is valuable, we are not simply making a descriptive statement. We're making a moral claim. And moral claims, once made, tend to carry consequences. The question is not merely whether life has value. The deeper question is what follows from that belief. When we look closely at the ethical choices societies face, we see that there are fundamentally different ways to interpret the value of life. One option is to emphasize autonomy. In this framework, the value of life lies primarily in the fact that it belongs to the individual living it. A life has worth because it is the personal experience of a conscious human being who possesses the freedom to shape its direction. If that principle is taken seriously, then individuals must ultimately retain the authority to decide the most fundamental questions about their own existence: whether to continue a pregnancy, whether to refuse life-sustaining medical treatment, whether to continue living at all. Within this model, the role of society is largely protective rather than directive. Institutions exist to safeguard freedom, prevent coercion, and ensure that individuals can make decisions without undue interference. Autonomy is treated as the highest expression of human dignity. Under such a system, individuals may make decisions that others find painful or troubling. A pregnancy may be terminated. A person suffering from unbearable illness may seek assistance in ending their life. Someone in profound despair may decide that their life has reached its natural conclusion. Society may try to help. It may offer counseling, support networks, medical care, and opportunities for recovery. But the final authority rests with the person whose life is at stake. That is one coherent moral framework. But there's another. The second framework places greater emphasis on preservation. Under this philosophy, society asserts that human life possesses an intrinsic value that does not depend entirely on individual choice. Life is treated as something worthy of protection, not only because individuals desire it, but because the community itself recognizes its importance. In this model, society may decide that certain choices should not be permitted. It may prohibit assisted suicide. It may intervene when someone attempts to take their own life. It may restrict abortion in the belief that potential life deserves protection. These actions reflect a different understanding of moral responsibility. Instead of treating life as something that belongs exclusively to the individual, the community claims a stake in that preservation. When the state prevents suicide, it is acting on the belief that life should not end, even if the person living that life believes otherwise in that moment. When the state restricts abortion, it is acting on the belief that potential life deserves protection from before birth. In both situations, the government is asserting authority over the beginning and the end of human existence. And this is where the deeper moral question emerges. Because once society chooses preservation, once it declares that life must continue, it cannot easily avoid responsibilities that follow. If the state claims the authority to prevent death, it is effectively saying that the continuation of that life matters to the community as a whole. But if life matters, the condition under which that life unfolds must matter as well. Preserving life cannot mean simply ensuring that a heartbeat continues. It must also mean that ensuring that the life preserved can be lived with a measure of dignity, stability, and security. Otherwise, the commitment becomes hollow. A society that insists that people must live while providing little support for the conditions of living begins to drift toward a troubling contradiction. It values existence, but it neglects the experience of existing. Consider what it means to preserve life in the most literal sense. A person could remain technically alive while lacking reliable access to food. They could remain alive while living without stable housing. They could remain alive while suffering from untreated illness, chronic pain, or crushing financial instability. Biological survival alone does not guarantee a life that reflects the value we claim life possesses. If the preservation of life is truly a moral commitment, then the conditions that sustain that life must also be part of the conversation. Food assistance, universal health care, guaranteed housing, access to education, basic economic stability. Within a framework that prioritizes the preservation of life, these policies are not merely political preferences or ideological experiments. They become moral requirements. They represent the structured support necessary to give meaning to the claim that human life has inherent value. Because when societies insist that life must exist, when it intervenes to prevent suicide, when it requires that a pregnancy result in birth, when it declares that life must continue, it is making a profound commitment. It is saying that this life matters. And once that commitment is made, it carries consequences that extend far beyond the moment of crisis. The responsibility does not end at birth. It does not end when the police leave the scene of an intervention. It does not end when a person survives a moment of despair. If life is truly valuable, the value cannot disappear once the immediate danger is past. It must extend across the entire human life that society has chosen to preserve. Otherwise, the claim that life is sacred becomes difficult to distinguish from the simple demand for endurance. A society that truly values life must do more than prevent death. It must build the conditions that allow life to be lived.